Okay. Hey, Vijay, I'm trying to share the outline. I'm not sure if I've got it open on my end. Okay, here we go. I think I got it. Okay. All right, can you folks see this?
Yep.
All right. So administratively, Raj, whatever questions pop up, I'm not taking track of those, but if you can, just let me know when we need to get into those down the road as well.
Sounds good.
All right, so hopefully everyone can see this document and hear us. So at a very minimum, you need to have wills. That's number one. Number two, and we're going to go through each of these documents in more detail down the road. Number two, a durable power of attorney, which relates to personal property assets. Number three, medical power of attorney. Number four, directive, which is, some people call it a living will. It's basically telling your physician, hey, remove life support if need be. Number four, or number five actually, is HIPAA release. You'd be amazed how many folks think they have direct access to each other's information, husband or wife, or even to their children. Without a HIPAA release, you're not going to get any of that. Declaration of guardian, that relates to both husband and wife adults and also to guardian of minor children. To the extent you want an organ donation form signed, I would recommend you do that either when you're getting your driver's license renewed or when you're making your wills or not. So these are basic documents. At a very minimum, anyone, including husband and wife, and moreover, in this day and age, your adult children, kids who are over 18 years of age, children who are actually out in the workforce making a living, they should have some of these basic documents in place. You'd be surprised how many folks have none of this, much less with their kids and for themselves even. And more advanced planning is what we call a revocable living trust. Again, these are just to sensitize you to what we're going to try to cover today. Hopefully we'll get to all of them. If not, I want you to know the nomenclature that we use, the words that we use to describe what assets, what documents are needed, right? So revocable living trust, you may have heard about this at cocktail parties or relatives may say, hey, I have a revocable trust. What does that really mean, right? And we'll get into hopefully more details on this. You can have people say, hey, I want to avoid probate. I want to protect my assets. Well, the way you do that is to have a holding company to hold some of your assets. So the living trust, again, minimizes your probate requirements upon your death, right? Then a much higher level planning is item number three, which is your estate taxes and income taxes. As Raj alluded earlier, there's only two things certain in life, death and taxes. You can't avoid either one. You know, your visa's up, you gotta go. Along with that, you gotta pay Uncle Sam taxes while you're alive and upon your death. You just can't avoid it. That's a necessity, right? Just the way it is. So at a higher level currently, and these numbers have changed slightly, for 2020, you could give up to $11.58 million to anybody under the sun, including me and Raj, if you feel so, $11.58 million without any estate or gift taxes. That's gone up slightly for 2021 to 11,700,000, give or take. So between husband and wife, you could theoretically give away close to $23 million without any estate taxes. That's slightly different, which we'll get to you for lawful permanent residence, which I think some of the questions alluded to the earlier email that we had. On top of this, you can annually give up to $15,000 per person as a coupon without any gift taxes. So in theory, you could give everybody on this seminar $15,000 without incurring any gift tax if you're so inclined, or if you win the lottery, you can give even more. So again, I'm not sure how many folks on this call are what we call lawful permanent residents or H-1 workers or what may be. But there are special rules for green card holder spouses. And under the current regime, the only way you can give up more money or even up to 11.5 is what's called through a qualified domestic trust. And again, these are things we may not get into. That's why I'm kind of giving you just a brief highlights on these things. And there are certain US tax treaties for Australia, UK, Canada, which we're not going to address today, obviously. And item number 4 is asset protection under Texas law. We have clients that walk into our office, say, hey, you know, I want to protect my assets from my creditors, whether they be business creditors or other creditors, right? So under Texas law and most laws of America, most states, you'll have what's called a homestead exemption, which basically means your house is fully protected from creditors except the one that you're borrowing money to pay for the house. Why is that important? Because the state of Texas and all other states in the US do not want homeless people. That's the public policy behind having the homestead exemption. You could also have separation of assets between husband and wife to protect assets, but that means you're gonna have to give up your community share to your wife, and conversely, she would give it up to you. God forbid you get divorced down the road, sayonara, you're basically out of luck. Life insurance and annuities are fully protected even in bankruptcy, so your creditor protection lies with life insurance and annuities. Similarly, you can put money away in IRAs and 401ks, and we'll briefly come back to this when we talk about children planning, and particularly Section 529 plans for children's education purposes, and even custodial accounts to the extent people are inclined to save money for their. You could have limited partnerships or LLCs to segregate your assets, right? To put money away in those accounts. Or you could set up what we call irrevocable trust, which are life insurance trusts, children's trusts, et cetera, et cetera. And again, part number 4, rule number 4 is more of the advanced estate planning along with number 3. We're not going to get into too much of it, but I want to spend a few minutes just to show you the nuances of more of the advanced planning phase 1, which is what we're going to try to focus on today, hopefully, because we have limited time. And number 5, and a lot of people kind of overlook this, they should consider increasing their liability insurance, either on their automobile insurance. If you have children who are newly licensed drivers, this is definitely something you should seriously look at, because the last thing you want to do is have your teenager driving around with underinsured amounts. You know, some people just go with the minimal amounts through their auto agent. It costs you pennies on the dollar to increase your liability insurance on your car. Similarly, on your homeowners umbrella policies that you guys have, you may consider increasing that to give you some asset protection. Prenuptial agreements, again, this is more necessarily to the next generation of kids, not Raj and my generation, but the generation after that who may need to worry about potential divorces down the road, where you're worried about segregating your assets, particularly children who are working in the workforce now, they're generating their own money, you know, and they get married. Yeah, maybe you ought to consider, hey, what's mine is mine and what's yours is yours and what's ours is ours. But we're not going to touch those again, hopefully, for today's presentation. So I want to go back to the very beginning, right? Let's talk about wills. Again, I'm not going to ask people to raise their hands to see how many people on this webinar actually have wills or not, but if I were to venture to guess, maybe 60, 70% maybe don't have it, maybe more than that. Why not? Why do people not have the basic wills in place? I'll give you a couple of reasons based on my 30 years of practice. One is they don't want to talk about death. Who does? Right? No one in their right mind wakes up one fine day and say, I've got to make a will. No, they're more worried about going to work, raising their kids, you know, making a living and going on vacations. Now, I can't blame people for that. But a will is a very essential part of any, just as you're buying automobile insurance, house insurance, life insurance, whatever you're doing it for a event in the future that may or may not happen, right? That's the essence of why we have all these things controlling our lives, you know, including planning for our kids. Why do we do that? Because we know in the eventuality they're going to need money. We're all going to need something. A will is a very essential that you're going to need today or tomorrow. Might as well do it today rather than later. And that's part of where our focus is going to be today. So a will is basically a revocable document. Keep that in mind. It is a revocable document. It has no effect until you pass away, until you've gone up to heaven. It has no meaning. So you could write it today, you can change it tomorrow. The only time you can't change it is when you're no longer around, right? So a will basically tells you or tells whoever survives you, here's how I want my assets to be distributed. Normally, husband dies, gives it to wife, and we always kill the husband first because the wives generally outlive the husband. That's an actuarial fact. Whether we like it or not, that's the reality. So husband goes, wife gets the money, wife goes, the children get the money, right? If you have minor children, it's even more critical to have a will in place because in the will, you can designate who you want to take care of the children while your husband and wife are both gone. That's the guardian declaration in the will. In the absence of declaring who the guardian of your minor children are going to be, Uncle Mahesh can show up one fine day, say, hey, I want to take care of the kids. Am I motivated by the children or am I more motivated by handling the money that's left for the children, right? Because as the guardian, I get to control the money that's in there, that's in the estate. And more importantly, I get to control how that money's spent. So you want to make sure that whoever you name as the guardian is the person you want to, number one, raise your children in your absence, number one. Number two, to manage that money in your absence, right? So a will is critical for people who have minor children. There's no way of getting around that. So now here's the good news. To the extent that 80% of Americans have no wills, the forefathers of this great land came up with a default language into the statutes of each and every state. It's called intestate succession, I-N-S-T-A-T-E. Now, what that does is we know, or the forefathers knew by statute, that most people aren't going to be doing these things because they're too busy attending weddings. And this is, again, pre-COVID, baby showers, graduation parties, et cetera, et cetera. So this gets low priority for obvious reasons. So it's under intestate succession, assuming you're only married once, by default, the surviving wife or husband gets all of the assets, and beyond that, the children get the money. So it's not the end of the world if you have no will, but it also means the state decides how and when to get the money out. So it's not the end of the world. So don't let anyone ever tell you because you have no will, the state's going to get the money. No, totally wrong. You, in the absence of, in your absence, the state is already predetermined who gets it. So if it's the first marriage, no problem. 2 marriages, big problem. So you can circumvent all that by having a will that declares how you want it to be. More importantly, for minor children, you truly need to have a will to declare guardians, right? Now I'm going to focus a little bit more on the wills because within the will, you can say, how do you want your money to be given to your children? That's why in parentheses, we have children's trust. Now, you know, when I started out as a young attorney with much hair than what I have now, I had the knee-jerk reaction that, hey, look, you know, husband is not here, wife's not here, give it to the children at age, you know, 30, 35, and 40 in increments, right? That's the logical reasoning. Is once they mature at age 30, give them a third. When they reach 40, give them whatever it is, whatever the husband and wife feel comfortable with. You'd be amazed how many folks have come into my office over the years saying, oh, give it all to my kids when they turn 21. I'm like, dude, I don't think you understand what you're saying. So after a little bit more coaching and education, so I'll move to age 25. And I'm like, fine, we'll do 25, 30, 35, whatever. Well, you know, in the last 10 years, I've kind of changed my thinking on this, and hopefully the listeners will agree with me, or if they don't, maybe they can explain to me why not. We all know our kids are great, right? I mean, that's the natural parent reaction is, hey, my kid can never do any wrong. I'm not worried about my kids. I'm not worried about your kids. What I'm really worried about is the influence in which they operate in our absence. That includes their spouses potentially, good or bad or indifferent. I don't really know, and truthfully, that's my job as an attorney is to guide you to the worst case scenario, not the best case scenario, right? So you could say in your will that upon husband's death, it goes to the wife, upon wife's death, it goes to my children. The mistake people make is either you can give it outright to your children directly upon your death, then the children can either blow the money, or number two, they can marry the wrong person, or they can get into the wrong business in which their personal guarantees kick in with their lender. So at that stage, that money is fully exposed to their creditors, right? Or alternatively, you could say at certain ages, I want the kids to get the money at age 30, 35, 40. That's all fine and well, but we don't know what stage they're going to be at that in their life at 30, 35, or 40. So what I've done in the last, I would say 10 to 15 years as I've matured with my clients is to say it will remain in trust for my children's lifetime. And they will be the trustee of that trust at age 30, as an example. So that hopefully they've matured, and to the extent they haven't, the money will still be in trust and they could use it as they need it, but it's protected from their creditors' claims. And, touch wood, most of our folks, most of our children, at least the ones I've come across, are going to be professionals, generally speaking, doctors, lawyers, engineers, business people, entrepreneurs, and whatever they may be. But generally, they're going to be at a much higher level than we currently are, right? So why give them the headache of exposing money that you've already gathered for them and on top of whatever they're going to generate? So I would advise folks, say, look, it's better to keep it in trust for their lifetime. Now, again, this may or may not be applicable to the audience at large here, but I have clients who are here for a relatively short time period and have built up a large amount of wealth, but they have elderly parents, either here in the US or overseas. So I always tell them, look, you got to watch out for who raised you. So do you consider leaving X dollars, 100,000, 200,000, 400,000 to your parents back home or parents here? Because understand, you're the primary source of survival for most of the parents at some point in life. If they're retired, then you need to make a provision for them in the will. And this goes both ways for husband's parents and the wife's parents. Again, we're in America, so we need to be cognizant of supporting both sets of parents, not just one, right? So you may consider in your will saying, hey, make it a disposition of a specific bequest to say, look, I leave X dollars or a certain asset to my parents if they survive me. Now, if they predecease you, then that automatically goes away. But, don't overlook that little bit of a tidbit, because some people do, and it's unfortunate because then the parents are left without a source of support in their old age, right? And I think I've covered the wills fairly well. If there are any questions, we can go through that prior to the end. Maybe, Raj, I don't know if I want to allocate 10 minutes towards the end, but I'll leave that up to you. And also, let's talk about durable power of attorney. Why do we need a durable power of attorney? Well, I tell folks it's the cheaper alternative to having a guardianship declared for you. And the reason for that is if you don't have a durable power of attorney, that means if, let's say, the husband or wife either has a stroke or is mentally incapacitated for some reason, and the assets need to be sold, either the house or the cars or business, wagera, right? How do you account for that? Well, a durable power of attorney should work, because that basically allows you to give power to somebody to say, hey, look, if I'm incapacitated for whatever reason, I give power to my husband or my wife or my adult children to convey the assets over, right? So that's why a durable power of attorney is very, very useful. In the absence of a durable power of attorney, you have to go to court to get a guardianship declared, then transfer the assets over, which is very expensive and it's unnecessary. So a durable power of attorney, as the word durable means, that is during your incapacity. A medical power of attorney, that's almost mandatory in my experience. That basically allows somebody to make a medical decision if you're incapable of making a decision. Then typically your husband will name the wife, and in the absence of that, they'll name the adult children. In the absence of that, maybe a close family member. A directive to physician, again, deals with making the decision relative to your physician to say, look, if I'm in a position of no return, then the directive of the physician has the authority to remove the plug on life support. Now, here's what I tell a lot of my clients. This is a personal choice. If you don't have a directive of physician, the medical power of attorney decides whether or not to withdraw life support. As a practical matter, no physician or hospital in its right mind is ever going to just remove life support without the family's consent. But where this helps is that if you don't have the directive of the physician, the medical power of attorney is left in the turmoil to decide, hey, do I really want to remove life support for my spouse or my father or mother, or whatever the case may be? That puts an enormous amount of burden on that person, right? So, and again, in the 30 years I've done this, I've had folks come into my office and around the conference table, a lot of tears have been shed where, you know, the son is literally sitting across the table and the dad says, hey, look, I want to sign the directive of the physician because I don't want to be in a point where I come out and my quality of life is going to suffer. Do I really want to do that? And the son says, are you kidding me? You want to leave without fighting? And dad says, yeah. I mean, at the end of the day, if my quality of life suffers, I don't want to go through that ordeal. So the point being, if you don't have this discussion, if you don't have that Sunday morning breakfast with your children or your spouse and discuss all of these 5 or 6 elemental documents, you're doing yourself a disservice. And one of the critical ones is the directive of the physician. You know, whether you're talking to your older parents or you're talking to your adult children, have that dialogue where you say, look, I'm giving you the medical power of attorney, but I'm also telling you I do not want to be on life-sustaining treatment. To the extent it's going to prolong my life. Yeah.
Great. No, Mahesh, I just thought I'd give you a little break here.
Yep.
Catch a breather. I think this is wonderful information that you are sharing with all of us. I think, you know, one thing I noticed about our community especially is that smart people, logical people, right? They all understand this. But one thing I'm perplexed, and I want you to answer this, is it very complicated to make this thing happen, like these directives, etc., for instance, the basic will, for instance? You know, is it very complex? Can people do it? What's keeping them from having that in place and taking the unfortunate risk of unplanned things?
That's a very good question, Raj. And look, and at the end of the seminar, we're going to make this available to you so you could email it out to the attendees. We have the standard forms for durable power of attorney, medical power, directive of the physician, HIPAA. We're going to give those to you, sample documents, right?
Thanks.
Yeah, sure. And these aren't complicated. I mean, it's not brain surgery, okay, guys? These are elemental documents. You don't need to go to Mahesh Patel to get. You can download it offline, cheap, okay? The motivation, Raj, is the critical thing. Is, and I don't mean to sound, I don't know what the word is, but I've had clients literally tell me.
Please be frank, because
I'll be frank
this needs
with
to
you.
be a wake-up call to our community, because
Right.
it's scary stuff out there, you know. And a spouse, if she's stuck with a unplanned stuff, I mean, look at what they are leaving behind for their spouses.
Oh yeah, it's a mess. I mean, no question, and I'll explore that in a second. But what happens again, maybe it's taboo because some people feel like if they talk about death, they're inviting death. I mean, as stupid as it sounds, I've had any number of people tell me, but yeah, you know, if I talk about it, the family gets upset. And I'm like, brother, it's not going to come by invitation. It's going to be there regardless of whether you like it or not. But, you know, I mean, I hate to make light of it, but some people feel that, hey, if I start thinking about death and talking about death, I'm inviting death. I mean, as stupid and asinine as that sounds, that's partly the problem, okay? Number two, it's not a priority because there's no value add to doing something that may not happen 20 years down the road, right? You buy a life insurance policy, but it's really a death insurance policy, right? But the marketing is so good, you want to buy it today, right? But you're really buying a death insurance. Similarly, you're buying car insurance because of a potential accident that may or may not happen, right? So there's value add right there because you're seeing a monetary incentive, but you don't see that with a will or a power of attorney because there's no real money at stake in that sense, right? I mean, you're not going to get a value add immediately. So I think the fact that it's such a distant possibility is what a lot of people kind of say, I'll do it tomorrow. Why do you worry about it? Let's go to the dinner party pre-COVID, right? So, but if you don't have it, what you alluded to earlier, which is, unfortunately, I think it's getting better nowadays where the spouses are co-equal in a lot of sense, right? Where they're more involved in the financial affairs of each other and they know what's going on, but there's still the old school where the spouse really has no idea of what the assets are and what's going on where. So this forces the issue, which is a full disclosure of where they stand.
Great.
And you have an honest dialogue.
Yeah, Mahesh, that's great. And I think, thank you again for making the basic information available. So folks, after this session, a feedback form will be sent to all. As you complete the feedback form, you will given access to a Google Drive, which will house at least 20 documents that Mahesh Patel has shared, his presentation, the checklist, the sample directive things, etc., for you to use, leverage, etc., right? So we will do that. Mahesh, couple of quick things, especially with the Indian community. One thing that you have said in the past, and I really wanted to get a little bit deeper into it, spouses are, some of them are citizens, some of them are green card holder, some of them are H1, some of them are H4. And there's an assumption, as you mentioned, that especially in the state of Texas, right, the spouse will get everything. But then I also heard that no, and in case of non-citizen, this is not the case. Can you elaborate a little bit on that?
Sure, right. So let's, at the most basic level, right? Texas is a community property state. That's number one. So you'd be amazed how many folks assume that if the bank account, let's just take the most simplistic example, the bank account or even the house for that matter, which are the two main common assets, or husband and wife, that's all it says. It's Mahesh Patel and Bhavna Patel. That's all it says. There's no other extenuation of that language, right? It's community property. So 50% belongs to me, 50% belongs to my wife. My 50%, I can give it to Hare Krishnas, or I can give it to Jai Swaminarayan, or I can give it to my wife. It's really my interest to give. There is no presumption that I want to leave it to my spouse. And a lot of people they're like, well, shouldn't it automatically go to each other? No, because if you remember, and I'm old enough to remember the movie War of the Roses, where they're literally splitting the house, cutting it into half, right? So the reality is people make the uncommon mistake, or I guess very common mistake, that everything is equally and it goes to the other person. No, you have to put it either in the will, or you have to do what's called the JTWROS, Joint Tenants with Right of Survivorship. Now, going on to the H1s and whatnot, or even the lawful permanent resident, there's special rules for estate planning purposes. I think their domicile, quote unquote, controls how the assets will be split. So typically you have to establish domicile. And typically, if you're in America, then the law of America will control as to those assets. Now, those assets are overseas. Generally, those will be controlled back in India. So what I've told a lot of clients is, look, you need to make sure whatever assets you have back home are re-examined and properly put in the right title, if you will, whether you want to share that with your relatives, you want to waive certain rights, you need to address those overseas. And we've actually got to link up with an attorney in India that we're working with. Eventually, we're going to make that even more available, where they could actually sign some documents here and maybe DHL it overseas with the attorney and have those things documented properly. So upon one party's death, it automatically is addressed and we don't have to worry about it, because believe it or not, in India, very nuanced differences there as well.
Great. I will turn it back to you, Mahesh. I think just to summarize the will part, that, guys, let's make sure that get your house in order so that these things doesn't catch you off guard, as you rightly said. Mahesh, I'm going to put you a little bit on the spot. Several people have shown interest in connecting with you after the session. They say that their employer has a basic legal coverage like JP Morgan, etc. Are you part of their legal shield setup that they can come to you? Because clearly, with the way you communicate, the transparency, the straightforwardness, I think is very important for our community.
Right. Now, I appreciate that, Raj. This has come up any number of times in over the last 15, 20 years. Unfortunately, we are not part of even some of this prepaid legal services or the employer-sponsored legal programs. And the reason is number one, we tried once or twice, and truthfully, the money just wasn't there. I'll just be honest with you, because what they do is they kind of knock you down to a dollar amount where it's just not economically possible unless you're doing a vast volume. And more importantly, Raj, what we've discovered is we've seen some of those work products, and truthfully, but it's just like LegalZoom on steroids is about all it is, because they give you the plain vanilla stuff. There's really no customization, if you will, for the lack of a better word, right?
Right.
So again, at a minimum, you ought to do it.
Yeah.
Take full advantage of it. Get the basic stuff in place. And if they have a follow-up question, if they want us to review whatever they've already executed through their employer plans, we can look at it and say, hey, you may want to change A, B, C, D, or maybe change nothing at all. But a lot of times, they don't give you a lot of the detailed analysis that we just presented today,
So Mahesh, I'm going to put you on the spot again, which is today you are kind of sounding the alarm bell that, hey guys, you got to get your S in order. Okay, this is important, especially with the COVID. And I mean, I'll be just blunt for the benefit of everybody. COVID has everybody shaking in their boots, right? I mean, we are seeing death. We are seeing, the issues of people getting sick and whatnot, right? People on ventilator, who's going to make the call, right? People are seeing that. People are hearing about it. People are nervous, and being nervous is not the answer. Get yourself organized is the answer. So today, Mahesh is sharing with you the importance of having the basic things in place. We will make the documents available to you. But here's what I'm going to put you on the spot, Mahesh. A month from now, can I invite you back to do one more session? And that will be a pure Q&A, because those who chose to take this seriously, right, and decided to do something, and they may have run into, I don't know what the heck to do here. What is the next thing in this process? So rather than everybody taking your one-on-one time, we can just have a pure Q&A session with you, and they have to submit their questions ahead of time. Would that be?
I'll be more than happy to do that. Look, I think this goes back to your introduction and our initial response to educate people. Look, I mean, as one friend told me, there's a lot of information on the internet, but there's no knowledge. It becomes knowledge when you apply a filter to that information, right? You can Google wills and estate planning all day long, but until you filter that information into a useful knowledge, and that's where the legal profession, whether it's me or some third party, that's where our years of experience comes into play, which is, hey, you're thinking this, but truly you ought to be looking at this, right? So that transfer of information into knowledge is where we add value, right, at the end of the day.
Right.
And I mean, just to give you a classic example, and I don't know if this applies to folks on this call or not, and one of the big hangups we have with people is who to name as guardian of their children. Because you'd be amazed how many folks in the US have very few close relatives physically residing in America. Either they've transferred to America in the last 5, 10 years or 15 years, and their siblings and their parents are back in India, right? And they say, hey, do I make Raj, who I've known for 10 years, as the guardian of my children? No. So what do you do? Because at the end of the day, part of the planning is I've got to name somebody to take care of my minor children if the husband and wife are both gone and majority of the family is back in India, right? Because you can't assume that if you name your brother, who's the one sitting in India, as the guardian of your children, fly into America and just take the kids back home to India, which is probably not the best solution, but that's what a lot of people naively end up doing, is they name the overseas person as the guardian, then from a complexity standpoint, administratively, it's very hard, A, to get that person into America, number one. If they get in, it's temporary. Number two, the kids may not want to go back to India. Number three, the US probably won't let them take back to India without a court order. Right? So you got multiple issues. So
that's a good point. You remember last year, Mahesh, there was an unfortunate accident in Frisco where I think a couple passed away, and you were inundated by people suddenly waking up and saying, oh my gosh, because CPS, right, Child Protective Services came and took the child because there was no declared guardian.
Yes.
Right? I mean, life happens, guys. I mean, and don't take this unnecessary risk. You love your children, and yet you don't want to fill out a simple form. Take the time to decide, who locally, as Mahesh said, should at least be a person that CPS others can contact, and your child future is safeguarded. Is it a very complex form for a guardian thing?
No, it's very, very simple. And I'm going to, again, try to share this, and hopefully it works. Bear with me, guys. I'm not the most astute technological person in the world, but
just be a good attorney. That's all we care for.
Yeah, man. Trust me.
You're a good man. Thank you, man.
We will try, but while we do that, and I know we had a lot of questions, and I want to allocate, Raj, probably about 3:10, and I know you have another person lined up here in just a little bit. What time do they need to come on?
They will need to come on around 3:15. So okay. I would recommend you have under 10 minutes to,
right.
And if you want to open up for Q&A, that's another, I'll leave it to you.
Okay, just bear with me 1 second and I will.
And in the meantime, I have encouraged folks, please post your questions. There's no such thing as a dumb question. Put it out there. If we can get to it today, Mahesh can get to it today, great. If not, I'll make sure that Mahesh has some response to you later on. But take advantage of having an attorney giving his time to answer our questions.
All right, so I'm gonna stop sharing. Then we're gonna get other interesting stuff here pretty quick, guys. Just bear with me here. All right, okay.
I guess those who have joined us late, folks, you missed the heart of the presentation, but we will be sharing some of these documents that Mahesh has walked us through. But right now we are in the middle of a conversation with Mahesh Patel, attorney at law, and he's going to share some important documents with you.
Can you see this one?
Yep.
So appointment of guardian for my children in the event of my death or incapacity. Very simple form, right? I mean, this doesn't take a genius to fill out and initial and notarize and be done with it. I mean, it gives you a peace of mind at the end of the day, right? I mean,
it begs a question here. How many here have children, and how many of them have this in place? I mean, if it is not 100%, shame on us. Sorry, guys, I'm so blunt because I care for our next generation. I think you care for our next generation. So at the minimum, we'll make this form available to you as part of the toolkit. And please get these directives and basic things in place so that you can sleep well and your children are taken care of.
Right. So I'm going to skip to a quick PowerPoint presentation so you guys can kind of go through this. And I think some of the questions we had prior to starting today, Raj, that you guys had emailed to me, I want to share this with you real quick. So people get the idea what we're looking at, right? So, all right, and cut me off about 3:05, Raj. So if there's any questions, simple questions we can get to. So can everyone see this? The PowerPoint?
Yep, it's coming across cool.
Right, simple wills. Do you see it? Raj?
Yep, it's coming through nicely.
So, exactly. So again, this is a generic will. The husband dies or wife dies, it goes to the husband or wife for lifetime. Then it goes to the children, whether or not it goes outright or in trust. We briefly touched on that. And one of the questions we had prior to starting this presentation was, should I leave children money outright or in trust? My inclination is always leave it in trust for the children, because we don't know what future holds for them, whether it's creditors looking after them or going after their money, or as we use in our jargon, predators. And unfortunately, predators could be spouses as well, right? So that's the unfortunate part of life. So you take the will, then you have to go through what's called the probate process, which is you take the will, you file it with the court system. The court has a hearing, and the court says, yes, the will is valid. You know, everything in there is performed perfectly in terms of the witnesses, timing, etc. Then you got to file what's called an inventory, which basically says to the court, here's what the person had at death, the house, bank accounts, etc., etc. Then it goes into the creditor, and then basically they distribute it out according to your will. The probate process, folks, in Texas, luckily, is not that complicated, but it's time consuming. It's anywhere from 6 to 9 months, right? And it's a little bit more involved if you have more assets. So you want to minimize probate as much as you can, right? Now, one thing to keep in mind is probate does not include, and neither does the will include, your 401k. That's a beneficiary-driven form that goes directly from the husband to the wife, or vice versa, if not to your kids. Now, one of the questions we had prior to this, should we modify our beneficiary designations? And yes, to answer your question, because under the more recent laws, what's happened is that the rollover is not available anymore to your non-spouse individuals. So to your children and your third parties, it's not available. So to spouses, yes, the husband or wife should always be the primary beneficiaries of a 401k. The secondary beneficiary, I would advise, either be the estate of that person, or what we're going to get into is called the living trust, right? Similarly, on life insurance policies, many people have life insurance policy. The agent sells the policy and you never hear back from them, right? Because their goal is to sell your policy. So you fill out the form, yes, husband dies, make the wife the beneficiary. And if the wife is not around, make the children the beneficiary. Well, you got multiple problems, right? Because A, if you name the children as a secondary beneficiary, husband and wife dies in a common car accident, let's say, right? The policy kicks in, the insurance company will not pay directly to the under 18 child or children because they don't have capacity to enter into a contract. Hence, you end up with a guardianship, which is costly and just pain in the neck. More importantly, when the children turn 18, guess what? They get the money, they can go and buy the Porsche. And whatever they want to do with that money, it's gone, right? So what you could do is name the secondary beneficiary. Secondary beneficiary, again, keep in mind, secondary, not primary. The secondary beneficiary could be a revocable living trust, which is to minimize probate. Some of you may already have a revocable living trust, some of you may not. So an alternative to a direct will is what's called a living trust. And the idea is you transfer your bank accounts, your house, your out-of-state properties, your mutual funds, your fidelity accounts, whatever you have, into this holding pot. It literally is a holding pot for husband and wife while they're alive. And upon their death, they can distribute it out as they want, because during their life, they're both husband and wife are the beneficiaries and the trustees, okay? Upon one death, it could turn into a bypass or a marital trust. That's more the advanced planning. But what you need to focus on is this level of planning for husband or wife is very simple. It's not complicated. Where the complication comes in is the second tier of planning, which is right here, is what do you do for your children? Do you give it to them outright when you're both gone, or do you leave it in trust? My inclination has been in more recent years to leave it in trust for the children, because that protects them from their creditors and from their own stupidity. Now, you could name your brother, you could name your relative that you know who's mature enough to handle the money until the kids reach 30, 35, or 40. Alternatively, you can name Bank of America, Chase Bank, Northern Trust as the trust for that trustee till a certain age, or for their kids' lifetime, you can name a third-party trustee. This is a $1 trillion industry with a capital T. The trust industry has been around ages, from the Rockefellers down to Bill Gates, right? It's not going away anytime soon. So the idea is to protect that money for your children, right? So again, I go back, some of you may already have a revocable living trust, but And you got to fund it. The key word is you got to transfer. You got to go to JP Morgan. You got to go to Wells Fargo and say, hey, instead of husband and wife as the owner of that bank account, now it's the Patel Living Trust that's the owner, right? And who controls that? Well, you and the wife are the trustees. You're the trustees while you're both alive. And upon both of your death, it goes to the children. In between, we have some complexity of whether or not we want to set up some bypass trust if it exceeds 11.58 million, et cetera, right? So again, keep in mind, we need to address life insurance, 401k, those are non-probate assets. Those are beneficiary-driven assets. They never come into the will or the probate. That's the key thing you got to keep in mind. There's another way to avoid the probate process. It's called JTWROS or POD, payable on death accounts. If you don't want to go through creating a living trust, what we call a poor man's alternative is a JTWROS. Don't assume just because it's husband and wife that it's automatically going to go to the survivor. It's not the way it works. Same thing with your children. If you have adult children who have bank accounts and it's you and you, the father or the mother, along with your child, it doesn't automatically mean you get that account unless you just, cancel out the account by writing a check without notifying the bank that this person's passed away. The better alternative is either POD or TOD, transfer on death or payable on death, or a JTWROS, joint tenants with right of survivorship, so that if something happens to your child or to you, more importantly, then it goes to the survivor without any issue. Just show them the death certificate and voila, you're home free at that point, right? Again, I keep coming back to adult children because a lot of us now are aging, Raj, and a lot of us have adult children, and believe it or not, the adult children don't even have the basic stuffs in place, man. They don't have a will, they don't have a directive of the physician, they don't have powers of attorney, and yet they're sitting on bank accounts at Chase or Fidelity, and they're trading Tesla and making bukus of money, yet there's no backup to their account.
Hey, that's a very good point. I didn't even think of that because I always thought that, okay, children are grown, I don't need to worry about guardianship. But you're right. I mean, we care for our children. So you need to make sure that they have their financial affairs in order as married and with your grandkids, right? I mean, making sure that, okay, do you have a guardianship for your grandkids?
Yeah.
I didn't even think about that. That's a good point.
Yeah, it's almost critical to do that, right? Without that, it's and it goes back to the very beginning of this session, which is, hey, when should we plan for our wills and trust? And to me, and I don't get me wrong, guys, okay, I think you ought to do it the day you're married, literally, or the week thereafter, because you're committed at that point, right? I mean, you go out and you buy a fancy house, you go out and you buy a fancy car, and you do all this other basic, okay, fair enough. But what about the most basic thing, man? I mean, it ain't complicated. I mean, as I was showing to you today, you can do it on Legal Zoom tomorrow morning, or even today, this evening, right? But the initiative we need to take to have that honest dialogue, right? To say, hey, here's the game plan, for the next 5 years or 10 years or whatever it may be. And it's just the natural thing that ought to happen, but it doesn't happen, unfortunately. And I think with folks like you're going to keep pounding the table, hopefully, and say, hey, wake up, Jago, let's get on with this, right? So that's hopefully the plan. Then, for those of you, who really want to do some more higher level planning, we do the bypass trust, the community property trust, marital trust, et cetera, et cetera. So that's all there. Again, but this is much of a higher level planning. So I want to come back to some basic stuff. All right, guys. And these are takeaways that hopefully you can implement next week, aside from trying to think about doing the will. If you have adult children, you ought to seriously consider taking them down to the bank and adding them to your security deposit box. You'd be amazed how many folks have not gone through that trouble yet. I'm trying to do it. I'm just not finding the time to get it done. So I'll be the first to admit. But, in both of our absences, husband and wife, you need somebody to be able to access your safety deposit box. It may have some important documents in there, right? So why not? Since we're all homebound, it's something to consider. Number two, you ought to seriously think about adding people who have access to your passwords. We all live in a digital world where everything is controlled either through ACH or some other mechanism, and there's no way to stop those ACH payments if you're gone. So how about giving or sharing your passwords amongst your family, or maybe writing it down, putting it on some digital wallet? I don't know. There's all sorts of ways to secure that, but it needs to be able to get into your digital life. For lack of a better word, your digital life needs to be accessible on your death. So I think as a housekeeping matter, adding your adult kids to your safety deposit box, giving access or having a checklist of list of passwords secured somewhere in your safety deposit box or somewhere electronically or whatever the case may be, that needs to be done ASAP, at a most basic level. Update your beneficiary designation for your life insurance policies, which we touched upon briefly today, right? Looking at your 401k, your IRA accounts, making sure your secondary beneficiaries are in tune with what you want. If you have 3 children and you want to say, hey, I want to give more to one child or 2 children because they may need it more than the other one, who knows? I don't know, and maybe you obviously could make that determination. But, do some basic baby steps, as I would call it. Look around you and see what's important to you critically, number one. What we talked about is updating your wills if you have old wills. Number two, if you don't have old wills, LegalZoom, your employer-based plans, prepaid legal services, get those in place, get the powers of attorneys in place, get the essential documents in place. If not, worst case, go to your bank and say, hey, I want to do a JTWROS. That's the acronym. That's the golden one, JTWROS, Joint Tenants with Rights of Survivorship, or POD, payable on death, or TOD, transfer on death, right? Those are simple. It's going to require probably 45 minutes to an hour and a half of your life, but you got plenty of life left. So why not start using some of that now to plan ahead, right? So we're at 3:05, Raj. So right on the dot of 3:06. Now we've got another speaker potentially on the back. So I don't know if there's any questions pending.
There are tons of questions, Mahesh. The one basic one I'll pose right up front is, do you practice outside of Texas? There are people who have joined from New York, California, Ohio, and they have asked, do you practice or could you help folks who are living in those states?
We can try. We've done it in the past where what we do is once we gather the information and kind of try to customize a plan, so to speak, right? We'll go ahead and draft those documents, then get an outside counsel in those states to make sure we're on par with what they need. And if they are, then we'll go ahead and supplement that and get them to execute it locally and good to go. But, where we add value, Raj, is the fact that we know our culture, number one.
Right.
Number two, we know the questions to ask. Because a lot of times, either we know the questions or they know the questions and they're hesitant to ask too, right? Because, they'll go to an unfamiliar person and then say, man, this is a stupid question. Should I ask? Should I not ask? And I'm like, look, the most stupid question is the one you don't ask because you leave it unanswered for infinity, basically, right?
That's a good point. That's a very good point. And I think I like that part that you bring that cultural sensitivity that you won't get from other attorneys. And another thing is that your communication style is one where you're straightforward. There's nothing hidden. What you see is what you get. Another quick question for you, and I'm giving some simple ones first.
Yep.
So let's say people get their act together, they get these documents signed, whether they use the form that you are sharing, whether they go to LegalZoom, whatever. What to do with those documents?
Very good question. So here's what we do in our office, and I think it works well, is obviously we give them the hard copy, which we recommend they put it into a safety deposit box or they put it into their fireproof place in their house. Number two, we scan it and we send it to them through electronic means, and we save them a PDF copy in our office, and we tell them to digitally store it somewhere. So you'd be amazed how many times we've had clients sitting in India and they say, hey, you know, my son needs access to that power of attorney. We're like, hey, you already have a digital copy and your son can access it sitting in India. Number two, we can send them a digital copy and it works beautifully. So in this day and age, and three, I think there's an electronic vault, quote unquote, that people can store documents up to, whether it's Google Docs or something else. It's there. Your daughter sitting in New York or California or Florida can access it, and they can say, hey, you know, Dad, I got it. No worries. You know, it's under control, right? So having that dialogue and having access to it is the key.
Great. And I clearly, one has to be cognizant about the sensitivity. You just cannot put it out there with Google and other open share platform. You know, there's a risk of getting hacked. So please be careful where you upload it for easy access, but that is the way to go forward. Another quick question for you is if a will is registered in India, does it have any value in US?
That's a tough one. I've never had it come up. I've had it come up the other way, which is we have an American will that we've probated and stamped it and sent it to an advocate in India to process in India, right? Which, you know, in Gujarat, we call it double ajamat, which is really not a good thing to do, which is if you have assets in India, you ought to take care of the assets in India because, you know, true, you're as a US citizen, you're subject to worldwide assets and income. But to duplicate the effort is meaningless, in my opinion. Now, to answer your question directly, it would have yes and no, because assuming it has all the formalities means that it was notarized in front of two witnesses, right? Then yes, the will potentially could have significance in America, but it has to have some meaningful language to tie up with the American system, which is, you know, you got to have an executor, you have to have the right documentation to back it up. And the more important part is the two witnesses to me.
Good point. So one other thing is that I think almost all of us have dabbled with the will, but a good question here is that in the will, you don't have place to list all your assets and the application. So
right.
where is that space? Where should we do it? How should we do it? Or should we do it?
Well, you asked a very good question. Here's the thing, Baya. We don't know what we're going to own when we die. That's the simple answer. Because you could have a house today, you could have 5 businesses, but it makes no sense to say I leave my house to my son when in fact you may not have a house or that particular house for that matter to leave, right? So it's a snapshot of your assets when you die. That's number one. Your will says whatever I have when I die, I leave to so-and-so. Now, if you're just hell-bent on leaving a certain ornament or a certain dollar amount, what we call a specific bequest, say, hey, I leave $500,000 to my aunt so-and-so or whatever, that's fine and dandy. Or I leave shares of IBM. You can do that, but it's meaningless in my opinion unless you plan on holding it for the rest of your life. Because if in our legal language, we call it the gift will lapse, LAPLSE, which means if it doesn't exist at death, it's gone, right? Because you can't trace the shares of the IBM that you sold to a dollar amount, right? So there's really no list of assets per se that we typically advise clients to do. Now, we give them a blank form that says if you want to leave certain jewelry items or certain souvenirs or certain family heirlooms to somebody else, yes, then you could say, hey, I leave the earrings attached, you know, or labeled so-and-so to my niece or my daughter or whoever. You know, those personal items can be easily bequeathed, if you will.
Okay, great. I think one of the things which people probably also fear why we don't go deep into estate planning, trust, etc. Because I'll be very candid with you. Attorneys that I have dealt with outside of you, Mahesh, I mean, they will say something, but once you are in there, the next thing you know, there's this bill, maintenance, monthly thing, annual thing. So a question for you is that if somebody is interested in setting up a living trust, ballpark, what does it cost? And secondly, annually or periodically, what should they budget for or plan for? Because I think our community does not like surprises on that front. So just if you can share some ballpark information.
Sure, don't worry. I mean, yeah, we're all Indians at heart. So unfortunately, that it's like going to the bazaar, and saying, give me 5 eggplants at the price of 2. But anyway, that's a whole story. But look, at the end of the day, right? Yeah, you're right. I mean, there's the intimidation factor with lawyers, right? I mean, and I try to take that out of the equation with a lot of people because my goal is, look, I'm going to run into somebody at a funeral or a wedding party or birthday party or somewhere or another. So I've got to uphold my end of the bargain. So generally speaking, you're talking anywhere from $1,500 to $2,000 to do a comprehensive wills or living trust planning. Okay, they could be as cheap as $850 to $900 to do a simple bare bones planning. On an upkeep, I wouldn't expect an upkeep for maybe 5 years, 10 years, unless the circumstances have changed. Whether you had a falling out with the guardian that you named for your children or the executors that you named alternatively for your estate or whatever. 5 years, 10 years, maybe upwards of $500 to $750 for those kind of amendments, if you will, depending on how complicated it is or not complicated. So in a large scheme of things, it's not very expensive, but it's good to have that up front.
Great. I have 2 more questions, then we'll wrap it up.
Yeah.
One is that they have with trust, they have encountered challenges in applying for loans, refinancing, etc. with banks. They don't seem to accept assets in a trust as personal assets to get the loan approvals.
Yep. Well, there are 2 components to it, right? I mean, number one, if you put your house like we envisioned here into the revocable living trust, number one, again, we'll talk in 2 respects real quick. One is your residential. How the banks don't like it because the title companies don't like it. The title companies cannot insure a house in a living trust, generally speaking, right? Because they're old. The title industry is so old, man. They don't want to change their ways. So, when you transfer a house into a living trust, they have all sorts of fits. But the state legislature in each state has said, no, the living trust can hold a house and any other assets, right? That's number one. So when you try to sell the house, you normally have to take it out of the living trust to refinance or to sell the house. No biggie. I mean, you kick it back out, you kick it back in. But there's that administrative process you got to do. With respect to any commercial loans you're trying to get for your businesses or whatnot, I've not had issues where if it's sitting in the living trust that it's not counted towards your assets because you're both the joint beneficiary and the trustee. I think the issue may be at this level where you've got assets sitting in the marital trust or a bypass trust or something. Then it's considered not your asset.
Right.
And therefore, they may throw some difficulty your way.
So, I mean, clearly it's not easy. There is some structural thing that they need to plan out for. So that's a good point. Last question, is there a tax return that one has to plan for and do it annually for living trusts or trusts in general, separate tax return?
Very good question, but whoever's asking this question has been through it before. So here's what happens, right? You have to have a good CPA on your hands, number one, when you do a living trust, because what happens is the living trust has no tax ID or should not, if you want to do it right, because since the husband or the joint beneficiaries and the trustees, the social security number for that husband or wife suffices as the tax ID number. Therefore, this living trust, whatever 1099 or whatever it gets will flow down to their 1040. Okay, so the living trust simply just files an informational, it's called a form 1041. So technically it's what we call in our business a grantor trust, Grantor, grantor trust. Basically it says husband and wife are basically owning everything instead of individually owning it together as husband and wife in the trust. So there's a very small informational return shouldn't cost very much at all if you have the right CPA. Then basically whatever you have here flows down to the 1040. So if you have $500 of 1099 interest on a bank account, or you sold some Tesla shares and you made 20,000 bucks, it comes under 1099 here and it goes down to only 1040.
Great, great, great.
Not complicated.
Several more questions, but I think, recognizing that we have another speaker lined up here, Mahesh, then I'm going to email these questions to you and request you to respond to them written. That can be then shared with, again, those who, there'll be a feedback form sent to everybody after this call. So those who are serious, and it's going to be simple 1-minute feedback form, we will give you access to the Google Drive with the document that Mahesh has said, as well as we will make sure that the question that have been posed, written responses to that from Mahesh will also be shared with you. Those written responses may come a few days later, but I will make sure that you get access to the documents as early as tomorrow, if not today. So with that, Mahesh sir, I can't thank you enough. Really appreciate that. This is the third time that Mahesh, upon my request, has spoken to my friend circle, network, and each time you amaze me with your simplicity, straightforwardness, and knowledge of the subject. So Mahesh, thank you, my friend.
Hey, Raj, thank you again, guys, and all of you for attending on Sunday. I appreciate the time and the courtesy.
Great, great. So Vijay, whenever you know what the score is of the playoff game, you may want to just put it in the chat session. But without further delay, I know you all joined in today for hearing from Mahesh about the estate planning and all the other things. We also have a speaker here who several of you heard in a earlier session that we conducted last month under the banner of Vigyan about trading as a business. So I put Gangaraju Hanumaya and his friend Kumar Bachu, who are the owners, partners of Right TaxMate, I believe, Right TaxMate. And they are going to be speaking about three things. One, we have a new administration in place, right? What is the thinking of the new administration? What should we prepare and plan for, right? Second, just the landscape, how it is changing from a tax perspective. And finally, give us some tax tips that we can start thinking about now to save on taxes. As I said earlier, we're not working hard just to pay Uncle Sam. I mean, we'll pay our fair share, but clearly if there are deductions, benefits that we can take advantage of, we want to hear it from him. I have also asked Kumar Bachu and Gangaraju to say that so that we can be a little bit better organized, share with us a calendar for this year. What should we plan? What are the due dates for whether it is corporate tax return to personal tax return to extension to whatever? What are some key dates that we should be aware of so that you all can plan out your life for 2021? So without further delay and taking time for their introduction, I'm going to turn the ball over to Kumar Bachu. Kumar, are you on?
Hi, Raj. Yes, are you able to hear me?
Yes, we are hearing you. We are seeing you. We see the lovely Golden Gate Bridge behind you.
Yeah. So I was not able to remove that.
That's okay.
It was there already, so I thought, let me go ahead with that. All right. Thank you for the introduction, Raj. Mahesh, thank you very much for the the presentation. It was a lot to kind of consume. And I know it will take some time to get into our heads and start taking action. I think it was very important for a lot of us who have not taken action to start taking action. I'll just share my screen. So you're able to see this, Raj?
Yep, we are on, correct.
All right, thank you. Thank you for all the participants who have joined on a Sunday afternoon. We are just going to cover on what is right taxmate, our credentials. We will talk something about the IRS updates, the latest IRS updates. We will also talk about the Joe Biden's tax vision. There are some changes expected. We will just cover on what are the main changes that are coming up. Some tax strategies to save taxes. And as Raj was talking about, just a tax calendar. So I'm just going to cover a little bit about our credentials, our background, and then I will hand it over to my colleague, Gangaraju. So Gangaraju will cover the other topics. A quick overview of our company, Right TaxMate. We are a team of about 35 tax consultants, CPAs, and DAs, spread over 5 offices in US, Houston, Dallas, Denver, California, and Chicago. We have our main corporate office in US, and we are starting a new office in Dallas. Last year we just started off with virtual. This year also we are going to be virtual, but probably next year we will have a dedicated office in Dallas as well. We pride ourselves with technology. I think Raj has been our client. He has been looking into our way of working. We use top of the line tax softwares, secure client portal for all of you to access all the documents, upload all the documents, and this is one of the key differentiators what we always look for. Our client list includes about 1,500 individual clients, 250 plus bookkeeping clients, and more than 50 plus auditing and other services. Our main vision is to be a trusted partner in tax, payroll, and adding value in every work we do. Some of the marquee clients have just bought it out here. We have clients, individual clients, mostly high net worth individuals. 85% of our clients are high net worth individuals. Our businesses range from kind of a $500,000 to $15 million. A very small business group is where we focus on. With this as an introduction, I'm just going to hand it over to Gangaraju. Gangaraju will talk about IRS updates and the other topics. Gangaraj, over to you.
Thank you, Kumar. Kumar, can you hear me?
Yes, I can hear you.
Raj, can you hear me?
Yeah,
okay,
you're coming clear.
Okay, great. Thank you for the introduction, and thank you for Raj for giving us an opportunity to talk a little bit about the taxes.
Gangaraj,
thanks for all the participants.
I'm going to interrupt you for a second. I am not just giving you an opportunity. You are going to be on every session of ours. I have dedicated 15 minutes in every monthly session of ours where we want you to come and inform us about tax saving strategies every month. So you are on the hook.
Thank you. So kind of you. I'll directly jump into the presentation. So Kumar already given a little bit about background about our company. So now coming to this is the right time for you to think about the taxes. Tax normally you should be well planned. We should be prepared for any kind of all your tax matters well in advance. But now we are in the month of January. Lot of changes has taken place. And IRS also getting ready to accept the tax returns for the year 2020. Normally, the filing window used to open in the month of January, second or third week of January. Because of COVID, IRS also has a lot of things to do. So the filing window has been postponed to February 12th. That means IRS will start officially accepting the tax returns from February 12th onwards. So as a tax professionals, we can keep your tax returns ready and we can officially electronically process your tax return only after February 12th. And this February 12th applies for all your individual return as well as if you have any business, the tax returns will be processed only after February 12th. So this doesn't mean that you should think about taxes or filing the return on February 12th. It is a good idea for you to, if you have received your W-2s, 1099s, or all your tax documents, you should start working with your tax professionals, or you can contact us. We will keep your tax return ready and process it by February 12th. And another latest update is this year, especially in 2020, you can contribute to your charity, and if you are not on itemized deduction, you can still able to claim $300 deduction on your tax returns. Any of the prior year, this was not the case. only this year, 2020, even though you are not itemized deduction, you can still able to claim the deductions on your tax returns. $300 charitable contribution deductions you can claim on your tax returns. And this year again, if you are an itemized deduction, you can deduct up to 100% of your annual gross income, annual adjusted gross income. If you donate, donate an appreciated stock, up to 100% of your fair market value of the stocks, 100% of AGI, you can take it as a deductions. And you can carry over unused flexible saving account. Most of you, if you're not spend flexible spend account, you can carry over to the next year. And you can also take the advantage of lifetime learning credit in 2021. It is similar to 2020. This lifetime learning credit applicable if you have any education expenses for yourself, and also you may have any applicable educational expenses for your dependents. If you are paying any tuition fee or because to improve your skills, you attending any educational institution, you are paying any education expenses for yourself, you can take a lifetime learning credit for the year 2021. So now let's jump into Joe Biden's tax vision. Joe Biden's tax vision, have mainly changing lot of changes in 2021 taxes, but officially it has not been announced. I doubt it will impact on 2021. We are still waiting from the president. But certainly Joe Biden's tax vision may impact for the coming years, that is 2021. But it is good to know what you may expect 2021 or later. So the important changes have been listed here, and these are all still on the paper. We just bringing it for your attention. As I told you earlier, it may not have any impact for the year 2020 tax returns, and also I don't think it may have an impact on your 2021 tax returns. Probably some of the these changes may be applicable in the coming years, that is 2022 or following years. So one of the major change that anticipating as part of Joe Biden's tax vision is there will be increase in Social Security tax. Earlier, Social Security tax used to stop if your income or if your W2 income is more than 137K. But now with Joe Biden's tax vision, you may need to pay additional Social Security tax if you have a W2 more than 400K. If you have a earnings, wage income more than 400K, you need to pay additional 12.4% Social Security tax. And also the tax rate, currently your top rate is 37%. This top rate will be increased to 39.6 for the any income is over 400K. And long-term capital gain and qualified dividend, if it is more than 1 million, if your income is more than million, then it may be taxed at 39.6. Currently, the long-term capital gain tax or qualified dividend tax getting taxed at maximum of 20%, but this may be will be taxed at the rate of ordinary tax rate, that is 39.6. And all these things, these are all the plan. Many people have asked these questions, so that is one of the reasons we are bringing it up in this presentation. And we are not sure at this point of time whether all these things will be implemented or will be rolled out, but just for information, we are just sharing this information.
Gangaraju, one quick thing. For the benefit of our participants, folks, I am going to request Gangaraju to share this presentation with me, which I can share with all of you. So don't worry about trying to take the notes down here. The presentation will be made available to you. Try to understand and then pose your questions based on that, and put those questions on the chat so we can ask Gangaraju at the end of it. So the presentation will be made available to you.
Yes, sure. Thank you, Raj.
Okay.
There will be a few restriction on itemized deduction. Currently, itemized deduction as property tax, mortgage interest, and any of the the charitable contribution you may have. So there will be a overall restriction on claiming the itemized deduction. So more guidelines will be published soon. And also for business owners, there will be a component called qualified business income deduction. The qualified business income deduction used to give additional 20% further reduction on the qualified business income. This will be eliminated if your income is more than 400K. And there will be a further changes on the ACA premium tax credit. We are hearing for the final update from the, we are expecting to get final update from the administration soon. So just to tell you, if your income is less than 400K, I don't think you need to worry about, or there will not be any impact or changes on any of your taxes. And further, it may help you to reduce your taxes, or there will be a favorable treatment for the the earners who have less than 400K. But if your income is more than 400K, certainly there will be additional tax liabilities, or additional taxes will be applicable on the income more than 400K. You can just keep a tab on your overall income, and if I just reiterating this point, if your income is less than 400K, you don't need to worry about it. Just you can ignore it. And coming to the business owners, the corporate tax rate going to be increased to 28%. And this is for a big corporate. Any income is more than 100 million, there will be additional tax will be imposed. This is on the book income. And additional benefits for adoption of a worker retirement saving plan. This is something applicable for the corporates. I will not spend more time. I'll just move on, because these are all applicable for the big corporations, Facebook, Amazon, those things. Coming to the tax strategies, most of the strategies, if you think and if you be prepared, you can certainly take a very good advantage of these strategies. We have broadly classified the tax strategies into two parts, personal tax strategies and business tax strategies. Personal tax strategies, there will be no 10% penalty with the newborn, or if you have an adoption during the year, up to $5,000 per individual per child. Especially if you have a 401k or any restricted account, retirement account, and you are looking to withdraw that amount, most of you know that there will be a 10% penalty. But in the year you have a newborn, if you withdraw $5,000 by you and $5,000 by your spouse, total $10,000. So you can withdraw it where you don't pay any 10% penalty. So this is something if you have a cash flow, you may withdraw it. Otherwise, you need to wait until you reach 59.5 years to withdraw this amount. And another strategy is materially participate to deduct rental property losses. If you spend 750 hours in managing together combined, you and your spouse together, you can classify yourself as a real estate professional. And most of the real estate properties generate a loss, a negative income, because there is a component called depreciation. So depreciation, where you don't put any money from your pocket, but based on the value of the property, you get a deduction on your tax return. So because of the depreciation, there will be most of the time, most of the real estate in the early years do generate a negative loss. A negative loss or a loss from the real estate property, not always deductible. So if you change your structure, and if you make yourself as a materially participate, you can deduct all the losses you are getting from the real estate properties. The next one, declare foreign rental property and take advantage of depreciation and travel expenses. This is one of the popular strategy. Most of us have properties in India. Some of the properties your relatives are living, or your parents are living in the properties. You still own the properties. If you still own the property, technically you need to calculate the fair market value of the property as a rent. And you need to disclose the rental income on your tax return. Being a US person, you are required to pay tax or report worldwide income on your tax returns. So this rule can be turned out to a strategy. So most of in India, rent, let's say I'll give you a quick example. Let's say you report 5,000 rupees as a rent. I've just taken the hypothetical number. So by reporting 5,000, you can write off the expenses you have on the rental property. You can write off the travel expenses. You go to your house, you visit the tenant, you make any improvements. So all improvement expenses can be taken as a deduction. Your travel expenses can be taken as a deduction. Depreciation can be taken as a deduction. Any any other expenses that are directly related to the property can be taken as a deduction. So most of the time, by taking consideration of all these expenses, it will generate a negative income, and the negative income help you to reduce your overall income. So you are one side taking care of the rules, you are disclosing your Indian property, other side generating a negative income that helps you to reduce your taxable income. Another one, convert IRA to Roth IRA to avail the tax-free growth. Again, there will be a strategy on timing. You should convert in the year you have less income. You should convert in the year you have, your tax rate is less. So, if you plan well, you can convert it, and rest of your life, you can get a favorable tax treatment. That is, you don't pay tax on the growth you make in the Roth IRA. Take maximum advantage of your employer flexible spending account, 401k account, HSA account. So your employer, if you are working for a large employer, there are lots of plans available. By contributing this, you can reduce your taxable income. And some places, your employer also contribute on your behalf. So learn about all the benefits you have and try to max out and try to take advantage of all these pre-tax deductions that would help you to reduce your taxable income. And another strategy is, if donate appreciated stock to a charity instead of donating the cash, the appreciated property or stocks will give you favorable tax treatment than you're donating to a cash, because an appreciated property will increase your charitable deduction, and also it will not create any taxable event on your tax returns. You don't need to pay tax on the gain, rather you get the direct charitable deduction based on the fair market value of the property. The next one is take advantage of kiddie tax. For a small kid who are less than 14 years of age, you can invest some of your the 1099 you get from your banks or from your buying stocks. You can invest through your kid's custodian account, and you don't need to pay tax on the income you generate in the custodian account. It will goes to your kid. Your kid always be in a lower tax bracket. If anybody wants to explore more about it, contact us. I'll share it with greater details or with an example. Business tax.
Gangaraju, I think we'll pause at this point because we had told everybody we'll wrap up the meeting by 3:30. So here's my suggestion. There are a few questions that have come in at this point. So let us address those questions and give back the Sunday to our folks who have come in. And those who are interested in the business tax strategies, I mean, one thing about Gangaraju, he's willing to do a separate 15-minute session one-on-one if you have things you want to discuss about property in India versus tax advice here. So I think there are a few questions. Gangaraju, can you see the chat window?
Yeah, I can see the chat window. I'm on my phone. Let me see the chat window.
By the way, first of all, for the benefit of everyone, you must have seen Gangaraju has dialed in from his spanking limousine or fantastic looking car. Gangaraju has been blessed. He and his wife have been blessed with a second child recently. So I'm sure that he's trying to make sure that he doesn't get disturbed during the session. So he's gone into his wheels and he's doing his session from there. So Gangaraju, thank you very much and thanks for your dedication. And rather than me posing the question, I thought if you want to pick the question and answer, would that be better? Or I'll be happy to do a Q&A.
Yeah, sure. You can pick any questions. I'm trying to find one.
Okay.
I'm on.
I'll do a LIFO, last in, first out. So what proof is needed to show rental, expenses for property in India?
Certainly a legitimate proof which has the detailed description of the work they have done. And, if you one is IRS always looks for who made the payment. If the payment is going out from your bank account, and if you have a invoice that shows that description, what kind of work you have done, and also if that is reflecting on your property. If I take an example, let's say you rebuild the kitchen, paint, or you painted your house. So the money should go out, the expenses should go out from the bank account, your bank account, to the contractor, whomever it has been paid. Second, that work should be completed for your house. Taking a picture of your house once the painting is done, or once the remodeling or an improvement is done, that would help, keeping and also paying that money directly from the bank account.
Okay.
So these things will help in case if you get into any kind of audit or any kind of questions if you get from that.
Great, great. So for Indian properties, we are filing in India, besides filing here, do we still need to, add them, taxes here? That was a question. Where do we show the expenses against the property in India versus here if you are filing in both the places?
So India, Indian income tax will be followed when it comes to disclosing the income or paying the taxes. India has a threshold. If you have only the rental property and if your income is less than 2,50,000, it gets changed every year. You don't need to file a tax return in India. Whereas here, you don't have any de minimis. That means even if you get 20,000 rupees rental income, you still have an obligation to report the rental income on your US tax returns. So you need to follow two different country tax rules. India, you need to look at the gross income you have during the year, and that will decide you have a filing requirement or not. US, you need to follow worldwide income reporting requirements. So I hope this answered your question.
I think if I'm not mistaken, the question is more of if I'm filing taxes in both the places, India as well as in US, for my rental income in India, where do I book the expenses? Do I book the expenses in India or do I book the expenses here? Obviously, I cannot book it twice.
Yeah, India, you cannot book the expenses you incurred. India has a standard amount you can take off from the standard, whereas the expenses which you are talking about, you will book on your US tax return.
Okay, great, great. Is there a statute of limitations on taking a loss on an investment in a company that you effectively consider a write-off?
Statute of limitation generally for a tax return is 3 years, and even that applies for a business returns. It's 3 years.
Okay.
But again, depends on the kind of the violation or a kind of non-compliant. Statute of limitations varies. So if the total violation or a total non-compliance is less than 25% of the AGI of that person, then it is 3 years. If it is more than 25%, it may extend more than 3 years. If the question is about only statute of limitation, I think generally it is 3 years.
Right. So I think this next question is pretty straightforward, but I want to hear from you. The 400K income bracket, that Joe Biden is talking about. So is that only applies for those on W-2 on payroll, or is it on the AGI, which could be part of 400K as a income, which includes capital gains, etc.?
So Joe Biden's first point, which I mentioned about the Social Security tax. Social Security tax applies only on the wage income, but all other taxes will be applied on the AGI, total AGI.
Perfect, perfect. Any increases to SALT? I don't know what SALT is, so let me also kind of put my glasses on. SALT tax caps expected?
SALT, state tax deductions, state and local tax deductions. So currently the limitation is $10,000.
Right.
You can only take $10,000 state and local tax deduction on your return. This may bring back to the full amount, and also it will have a the impact on the AMT tax. But currently, no clarity from the Joe Biden's plan.
Okay.
But currently it is $10,000. The limitation is $10,000, 2020 and 2021.
Well, I think that if I may, I'll just add a question of mine. Property tax also is capped at 10,000. Do you see that changing?
No, state and local tax, property tax together, the cap is $10,000.
Oh, together capped. Okay, got it. Got it. Is high school courses qualify for lifetime learning for kids that can be claimed?
Yes, there are two types of credits available. One is lifetime learning credit. Other one is, the regular education credit. Lifetime learning credit has no limit, as the name suggests. So the high school still can claim the lifetime learning credit, even if you are at work and to excel or to improve your skills, you enroll to a college or any kind of educational plan. You spend money, and it is paid to eligible institutions, a qualified educational institutions. You can claim the lifetime learning credit.
Great. There is a question here from Krishna about, please share ways in which we can create custodian accounts. It goes on to say, most companies like TD Ameritrade don't allow accounts or joint accounts with minors. Before you answer that, Gangaraju, I'm going to share something. I have my grandkids' custodian accounts with TD Ameritrade. So I do not know, Krishna, if you're running into an issue, let me know. I have a personal banker there. I can at least get you in touch with them and we can pursue that. But Gangaraju, do you want to add anything to that?
Yeah, I think they're confusing with a joint account. Joint account are different than a custodian account. So if you ask them, you need to open a custodian account, you should able to open a custodian account. Even for a newborn, baby in the year one, you can open a custodian account.
Okay, great. So earlier there was that one question about the limitation. I think there is a follow-up to that. It was really more about, I meant taking a loss, such as private shares bought in a company that are no longer viable. Is there a statute of limitation to that?
I meant taking a loss such as private shares bought in a company that no longer think is viable. I'm just reading that question.
Yeah.
No such rules. Even if you are investing in a private company, if there is a loss, you're still able to claim the loss on your tax return, but there will be a limitation of a $3,000 loss can be claimed on your return. Any loss more than $3,000 will be carried forward. I hope Krishna is asking about the capital loss carryover. The capital loss carryover of $3,000 limit. That's
right. But that can be offset. Let's say, I'm just trying to think out loud and trying to put myself in Krishna's shoes. Let's say I invested in XYZ corporation, right? And I got shares for that and they are worthless. So I take the loss. I can take only $3,000 every year. But on the other side, I have invested in the stock market and I bought a bunch of Apple shares and I got a lot of gains. Can I offset my business stock loss with my trading stock gains?
Yes, you can. So a different account will be reconciled on your tax returns. So you can offset any of the loss you have from any of the capital gain for that year.
Great. I hope, Krishna, we answered your question. Another one is that can we show private school fees for middle schools and take any tax benefit?
Private schools fee, you can. I think the question is more about the qualified tuition plan. The private school fee, especially that may not be eligible for a tax credit, but you can use the private school fee from your 529 plan. But private school fee will not generate any tax benefits. But you can use 529 plan to fund the private school fee.
Right. Hey, Kumar, can you go to the last slide so people have your contact information? Oh, calendar. Let's talk about the calendar before I forget it. Gangaraju, why don't you go to the calendar and then wrap up the meeting?
Sure. So this calendar is mainly focusing for the tax calendar. Anybody who have a business to taking care of compliance, there are couple more additional due dates that needs to be updated. We will update and then share it with you, but not to confuse. This calendar will be applicable for large group of participants today. So if you are expecting any 1099 or if you are expecting any W2, ensure you receive by February 1st. And for any reason you work for somebody, you performed any activities, if you're not received by February 1st, you should notify your the employer or whomever you worked for. So ensure you get the information. Most of the time, it happens that the employer will submit 1099 or W2, and the recipient not receiving it, they may not report on the tax return. So IRS will have a discrepancy that leads to a tax notice and penalties later. So just to be sure, ensure you are receiving all your tax documents by February 1st. And especially for the small business owner, you need to mail the if whatever you are issuing for your employees or anybody contractor, as a business owner, you need to mail the 1099 or process 1099 or file 1099 by March 1st. March 15th being the tax deadline for partnership and S corporation. All flow through entities must file tax return by March 15th. If you are an individuals, your tax filing due date is April 15th. And if you are a corporation, INC, and you are doing a C corporation tax return, again, the tax deadline is April 15th. And individuals who have made income from capital gain or sale of business or any other than the W2 income must estimate the taxes and pay the estimated taxes by April 15th. So, or if you have any business income, you must estimate the taxes and pay your quarterly taxes by April 15th. The reason you need to pay the estimated taxes is because IRS expects you to pay taxes as and when you earn the income. So if you have an income in the first quarter, IRS expect you to pay the taxes in the first quarter. And if you need for any reason,
let me interrupt you for a second. You had also shared with us about trading as a business. So let's say I have trading as a business, and in the first quarter I made a ton of money. Do I need to take some portion of it and pay to IRS as part of my quarter?
Yes, absolutely, yes.
Okay.
Yes, absolutely, yes. If you have a business income, you earned any income, you need to pay. Not paying the estimated taxes will lead to penalties, underpayment penalties. So it's very important to identify your income, do your bookkeeping, and pay the estimated taxes in the quarter you earn. So first quarter estimated taxes to be paid by April 15th of 2021. And if for any reason you want to file an extension, you are not ready to submit your tax return by April 15th, you should file an extension, and filing an extension deadline is April 15th.
Great.
May there is not much. June, again, second quarter estimated taxes to be paid by June. And September, third quarter estimated taxes. And if you have filed an extension, you should file your business tax return by September 15th, and that is partnership or S corporation returns. October 15th is the deadline for individuals who filed an extension in April, and corporation return also to be filed by October 15th.
Great. Wonderful. I think, folks, we kept you on a little longer than we had planned, but looking at the number of people who are still signed in, is definitely topic of interest. So thank you very much for sticking around. I'd like to thank Mahesh Patel, Ganga Raju, Kumar, behind the scene, Vijay Asava, and also want to thank Suman Chapuri, who jumped in and shared his Zoom account with us when the Google Meet failed. So thanks all around. One thing, as I mentioned a few times, I'll just recap. there will be a feedback form sent out. Please fill it out. We want to know your experience. We also want to capture what are topics and speakers of interest. So in the future, we can bring in relevant topics to you under the Vigyan banner. And the whole purpose of this is knowledge sharing. Our goal, just FYI, is we want to bring you sessions like these every month. Maybe I'm being too ambitious, but based on the feedback I will receive after this session, we will try to get on that. So our goal is to do it on the 4th Sunday of every month. So today is January 24th, the 4th Sunday. So the 4th Sunday of February, we'll bring another topic, another speaker. We'll also still include Gangaraju, talk about tax tips. So that's our goal. And hopefully you found this of value and a good way to spend a Sunday afternoon and learn and hopefully save money and make money.
Thank you so much, Bhaiya, and everybody else. Really appreciate it.
Thanks again,
Yeah.
Mahesh. Thank you, Anita. And thank you everybody for joining. This was very encouraging. We had almost 90 some people at the peak, and we had 60, 70 people even till the end. So that is a great show. And we'll continue to build on this. Namaste,
Okay.
everyone.
Take care.
Thank you.
Bye.